that that helped me a great deal. And despite, I mean, there was not any acrimony between the candidates. Now, I will say that when I first got appointed, that the Michigan Chamber of Commerce took issue with my candidacy because I came from a plaintiff's law firm, Scharfus, Christensen, and Archer. And they felt that I would be too liberal to this, to that, and the other. But there was a person that I had met and come to know, and thus he knew me, by the name of Richard Van Dusen, who was a former partner in Dickinson Wright, where I was ultimately a partner in the scheme of things. And Richard Van Dusen was also chair of the Detroit Chamber of Commerce. And because he knew me, he invited me to come up to the Mackinac Policy Conference. I was given an opportunity to speak before a plenary session.
That conference could be characterized as the business retreat annually of Detroit and corporate businesses in Michigan.
And that was something, by the way, I became chair of the Detroit Regional Chamber 2006, 2007, after I left office as mayor. But Richard Van Dusen gave me an opportunity to come before the Detroit Regional Chamber. And I was able to, through him and through the chamber, meet a lot of different business organizations. And they were satisfied that I gathered that I was safe, I was okay, and they could get behind it. And so I was able to win. And I won an 8-year seat. But we experienced in the city businesses leaving the city. You might recall back then it was jackets and gym shoes that kids were fighting over. Some were being killed over to take their jackets and gym shoes, certain style of jackets, certain style of gym shoes. And so I was asked, why don't you consider running? I really enjoyed being a member of the Michigan Supreme Court. I served with Mr. Chief Justice G. Mena Williams and Jim, who's a former, Jim Brickley, who's a former lieutenant governor. And by the way, Jim Brickley was the one who, when he was running for governor, you might recall, he tried to advance and get the petition signed to appoint, for whoever the governor would be, appoint the Supreme Court, Court of Appeals, education posts, etc. Because, you know, U of M, Michigan State, Wayne State, State Board, you run and nominated by your respective parties. And so he tried to get signatures, and he couldn't do it. Didn't win the election, but then he was appointed to the, and won or was appointed to the Michigan Supreme Court. And to go back to your original question in terms of Justice Ryan and Justice Kelly and their views, Governor John Engler was in a position to appoint a number of justices because of vacancies on the Michigan Supreme Court. And he did that. And they had a uniform, it was believed or observed or documented, whatever you myth or whatever the case may be, that they had a philosophical belief that was anti-plaintiff, pro-business. And there were a number of cases that came before them that, in their view, on the basis of the facts and the law, that decisions were made, and when you look at the decisions, the decisions was consistent with a pro-business point of view and an anti-plaintiff point of view. And so we finally got in the state of Michigan to the point where there was, I believe, 3 who were running for election at the same time. It just turned out, happened to be that way. Somebody was short-term, or I should fill in the vacancy, and then 2 who were running, I think, for a full term of office. And they were all nominated by their party, the Republican Party. They had 3 candidates from the Democratic Party that ran against each other. And I think $12 million plus were spent. A lesser amount by the individual candidates themselves, but the business community had a huge, because they saw the advantage of having people who they felt understood their point of view and was in the best interest of the state of Michigan. And so they raised a lot of money and supported the 3. And the ads.
So this was a PAC supported by the business community, but it was not a PAC administered or supported by the candidate him
That's
or herself.
exactly right.
It was independent.
Independent
of them.
And the same as it relates to the Democratic candidates.
Yes.
And those who raised money supporting the Democratic candidates, the PACs, they had some real interesting ads. I can still remember to this day one ad talking about, don't worry about the, what are we going to do about insurance? Don't worry about it. Don't worry about it. We've got 3. And you'd see the animation of 3 people jumping up and down and going in and pulling out money and all that kind of stuff where they were supposedly being paid. And it was a vitriolic, very nasty campaign.
Right.
The 3 Republicans won. And then it was about that time that I was coming in as president of the president-elect of the American Bar. And the then president of the American Bar asked if I would meet with, because they had an initiative in the ABA, let's tone down the nastiness of the elections. We had a meeting here at Wayne State University, called in both the Republican and Democratic state party chairs to see if we could not get an agreement to reduce the negativity and the like. Because it was not only here in Michigan, it was in Texas, all over the place. It was just, it seemed like it was just something that everybody was doing. And it was not good for the rule of law, and it was not good for the respect of the judiciary. And I will tell you that I was very pleased with what I saw here in Michigan. They toned it down. Then it popped back up again. And so that's why I believe that the 2 justices in their commission, and by the way, the commission was made up also of plaintiff and defense lawyers.
Yes.
Who also agree. So it was bipartisan across the board, philosophically balanced and the like, and they came to that conclusion. I remember, however, a person that I consider to be not only a mentor but a friend, Mr. Chief Justice G. Mena Williams, was always of the opinion that the voters better understood what they felt was important than anybody else, and therefore he was ultimately opposed to taking away that vote of the people.
Seems to me, injecting my own perspective, that you get, or are more likely to get, public ownership of the system of jurisprudence if there is an elected judiciary, or at least there's that opportunity, if somehow we can communicate with people and answer the questions they need to have answered. You know, that these ads don't characterize the system, but I don't know how you do that. It's naive to say, let's be nice and stay on point. But doesn't election provide greater ownership, at least, of the system?
Using your word, Lynn, I think it provides the opportunity. In reality, our media, press, both TV, written, print, etc., has never really provided an opportunity to appreciate and know the candidates, where they are, what they stand for, and to elevate in the minds of our voters how important the judiciary happens to be, and how what makes this country, frankly, so different and so much greater than everybody else is the respect for the rule of law and democracy. Madam Justice Sandra Day O'Connor, in an opinion, I'll paraphrase, and simply said that the United States Supreme Court does not have an army to enforce its opinions. We count upon the citizens to respect the rule of law. Well, the people who best share with the public how to respect the rule of law, and if you disagree with a decision made by any court, whether it's in the state of Michigan, the Michigan Supreme Court, or the United States Supreme Court, is to go either to the House and Senate of your state or House and Senate of the federal government and seek relief, etc. And so, since that is not something that is available, and because judges can't give, and frankly, neither can members of the Senate or the House, they can't give people jobs. It's not patronage, and they can't appoint people to do things as a president or a governor or a mayor can do. And so it is the only thing that lawyers could do, or judges running for office could do, is to say, I will be fair and impartial. And if asked, well, if the issue of abortion comes up while you're how would you rule? I'm sorry, I can't answer that question, because if I do, the other side would be able to file a motion asking me to recuse or remove myself from that decision process because I have a preconceived notion about how the outcome should come. And so I can't answer that question. Then there was a United States Supreme Court case, I think was either Wisconsin, Minnesota,
Yes.
I think it was the White case,
Yes.
I think, that the Supreme Court said that you could respond in certain instances. But even though the United States Supreme Court has said you could do it, most do not. And so I come back to this. Until the media gives full attention to the office and what that office does and can do, whether it's probate, circuit, district court, the Michigan Supreme Court, Court of Appeals, and until they help educate. And the Bar Association tries to do it. And frankly, more lawyers than anybody else have an interest in who's serving on the bench, because lawyers have a chance to know who that person is, what they're about, so that most elections in our state, as far as the judiciary is concerned, whether it's and it's more for the Supreme Court than Court of Appeals, Circuit, etc. Whoever heads the ticket in the state, if that person, whatever party, or persons, whatever party, wins that state, they carry with them the educational board seats, and they also carry with them whoever's running generally for Michigan Supreme Court. Now, every incumbent, in this last election, for example, Mr. Justice Markman, Mr. Justice Zera, they had what is called the incumbency designation, meaning under their names if they timely file, and everybody does, whether you're running for district court, etc., you're able to list your office. And so in this case, under Mr. Justice Markman or Mr. Justice Zera would be Justice of the Michigan Supreme